Well, hello everyone who is joining the webinar. I am Anne Seurynck. I'm with Foster Swift. And I really appreciate having the opportunity to talk to you today about Freedom of Information Act. I've been practicing law for almost 29 years now and municipal law the whole time. And one of the areas that I specialize in is Freedom of Information Act compliance. I have done webinars and speaking on FOIA a number of times, but I decided to take a little bit of a different approach today because we have been seeing our clients and other communities around the state. There's been, I think, an uptick in FOIA requests. And so some of the communities that may not ever do FOIA requests, may do them very infrequently, are starting to see FOIA requests. So what the presentation would be today would be to give you all the basics of FOIA, but in a way that really tells you how to approach a FOIA request when you get it in. So step-by-step approach to handling FOIA requests. One of the things I want to tell you is that especially if you don't handle a lot of FOIA requests, it is our advice always to get your attorney involved. Sometimes they will spot things that you should do in an initial request response that may prevent you from seeing an appeal on that FOIA or prevent litigation. So particularly if you have questions, it's always a good idea to loop your attorney in. And obviously this is not legal advice. This is just a presentation of information. So again, seeking your particular lawyer's counsel on a FOIA request is always helpful. So before you even get a request now, so let's just say you don't even have a request that's pending. There's a couple things that we recommend that every community does. One of them is to make sure you have certain documents that have been approved by your board or commission council. One of them are Freedom of Information Act procedures and guidelines. Secondly, it's a written summary of those guidelines. And the third document that you need is a detailed itemization sheet. And that's a sheet that you can fill out and it'll become a little bit more understandable once we get to talking about what fees you can charge. But those are the three documents that FOIA requires. Since 2015, you're required to have these policies and documents in place. Prior to that, you could just follow the Freedom of Information Act, and that was fine. But the amendment in 2015 required these documents. So if you don't have these documents, I think that's the most important thing that you should do, not only because it is required by the statute, but if you don't have these documents in place, you cannot charge any fees. And once you get an expensive FOIA request, you'll understand how important it is to be able to charge fees for that request. But you have to make these procedures and guidelines publicly available by providing free copies on your website, if you have one. In any Freedom of Information Act response, you have to either provide a link or provide copies, and they have to be available to those people at the office. So if you don't have those documents, that's the first thing I would do, is to make sure that your public body either has approved them, and if so, put them on your website if you have a website. And if you haven't, that's very important that that gets done soon, particularly before you get a FOIA request. You should also understand who the FOIA coordinator is. Every procedure and guideline should state who the FOIA coordinator is. And for cities, townships, villages, counties, departments of state, and anything under the control of those organizations, you can pick who your FOIA coordinator is. And make sure you choose them by title and not by person. For example, the township clerk is the FOIA coordinator, and not put that individual's name in there, so that the policy doesn't have to be amended if somebody leaves office or if that person no longer is with your community. A rule of thumb is that person should have a good idea of how the records are kept. Usually it's a board secretary, director, of an organization, clerk. But for other public bodies, I know there's a number of different types of public bodies on here, public libraries. It's the chief administrative officer of the public body. So unless you were in the group of communities or public bodies on the slide before, you don't have a choice of who your FOIA coordinator is. They are the chief administrative officer of the public body. For any FOIA coordinator, you are responsible for accepting and processing requests. The FOIA coordinator has to sign any denials that's required by the statute. You can designate another individual to accept and process requests. And this is often done with, every type of public body, particularly if you have the chief executive officer that might have a multitude of duties and you don't necessarily want them digging into the weeds on a FOIA request. That person can designate who the FOIA coordinator is, who their designee is, but we recommend that be done in writing. So those are the preliminary things to consider before you get a FOIA request. So what happens when you get a FOIA request? So the first thing that you should take into account is, does the FOIA request contain the information that's required by statute? And there was a recent amendment, it's been a few years now, but it's more recent, that the requester has to provide some specific contact information. So stepping back, the FOIA does not require that you state a FOIA request is a FOIA request. You don't have to cite to the statute. A FOIA request is simply any written request for writing, a written request for documents that's in writing. So if someone sends you an email that says that, I want a copy of the minutes from the last meeting, that's a FOIA request, even though they don't say pursuant to FOIA. So it's really important to understand that the FOIA is very user-friendly for requesters. They want to make sure that the public policy of the state that, that citizens have access to public records is fulfilled. And by doing this, they don't have a lot of technical requirements for what the content of the FOIA request has to say. So if it's a request for records, that's an important training point. This is a tip we want to pass on, that if you have people that in your organization that typically interact with the public, they need to recognize what a FOIA request is, because they might receive an email, they don't see FOIA in it, they don't really think of it as a FOIA request, but any request for public records should be passed on to the FOIA coordinator. Verbal requests are actually specifically permitted. You have to be very careful with verbal requests. And I'll go back to sort of a theory I have with FOIA, is that no good deed goes unpunished. So one time you'll request, or you'll grant a FOIA request that's a verbal request from somebody. They may come back and ask for a more complicated request. And then after they put it in writing, then often there's, they feel that there might be some reason why you don't want to request it verbally. You did it last time, or you answered a verbal request for another citizen, and now you're not doing it for me. You must not want me to have those records. As a general rule of thumb, my recommendation is always to seek a written request for public records. That way there's no miscommunication about what they're asking for. You're treating everybody the same, and there's no discrimination claim or other claims of different treatment among your constituents or patrons or citizens. So, as I mentioned before, one of the new, relatively new amendments to FOIA is that the requester has to provide certain contact information. And this stemmed from a FOIA that was received, years ago from, they call it the Emily FOIA, and some of you may have received it. It was a FOIA request for election records, and all that there was an email address, and then it was signed by Emily. And nobody knew who Emily was. They don't know what organization she's with. Nobody could contact her. And so the legislature said, look, we need to amend it so there has to be certain contact information. So you have to have their complete name and address and contact information for a person. So you can no longer have a FOIA request just from a company like ABC Company. Now it has to be from Joe Smith at ABC Company, and they have to provide that contact information, including a postal address. So be careful if you get FOIA requests by email. Oftentimes they won't give you their address. It'll be from somebody, and they will have an email address, and they'll ask you for records. And if they don't have a postal address, that's a problem. So it's a name, address, company you're working for. They either have to have a telephone number or an email address. So if you get a FOIA request by email, from somebody that has the email address in there, obviously, and they don't have their phone number, but they have their address, that's fine. So again, it's address and either a telephone number or an email address. So this essentially prevents anonymous FOIA requests. There was a recent FOIA, there's a company out of Pennsylvania that allows you to submit them, they say confidentially, and they use the same person's name. So if anything looks suspicious with the FOIA request, if anything looks like it's not right, if they're asking for records and the contact information does not look right, contact your lawyer and make sure it's a valid FOIA. The other group of people that are not allowed to FOIA are people who are sentenced to imprisonment in the state or a correctional facility. If they're serving time in prison or in jail, they're not allowed to send FOIA requests. So if you have either of these two circumstances, the proper response is not to deny the FOIA. So you don't say the FOIA is denied because you don't have the correct address in there. The correct response is that the municipality, the public body, is not going to process your request because it doesn't meet the requester didn't provide the correct information under the Freedom of Information Act request. So that's important because any denial triggers certain rights, and we'll get to that under FOIA. So you want to make it clear that it's not a denial. You're just not going to process the request because it's either from someone who's incarcerated or someone who does not have the proper contact information in their FOIA request. If they do end up giving you their address and that information is all correct, then of course you could move on to step 2. Step 2, and this is very important, is meeting deadlines. You want to make sure that as FOIA coordinator, you are ultimately responsible for making sure that deadlines are being met. So if you've reached out to people about documents and you're trying to process it and you haven't heard back, ultimately you want to make sure, because you're going to be responsible for the deadlines, that everybody's on the same page with the deadlines. So once you get a valid FOIA request, our recommendation, the first thing you do is to calculate the deadlines. The deadline that the first response is due, or the deadline, if you have it a 10-day extension. There was a relatively recent amendment that dealt with emails and getting FOIA requests by email that are in your junk folder. If it's sent to your junk folder, it's not considered received until 1 business day after it is sent, or it's not considered received until 1 business day after you first become aware of the written request. So if you receive something in your spam, make a note of when the day that even if the email was sent a month ago, if you received it today, for example, make sure that you know that it was received today and that it's not considered, it was sent, you discovered it today, and it's not considered received until 1 day after you discovered it. I will make a note for electronic. So if something's sent either electronically through the website, by email, or by fax, it's not considered received until 1 business day after it is transmitted. So for emails, if it was sent on a Sunday night, it's not considered received till Monday, unless Monday's a holiday, and then in that case, it would be Tuesday. So if you receive it in the mail, it's actually considered received the day that it arrives in the mail. This is very important if you are a community that is only open a couple days a week. You need to be really aware of when it's received. A business day is Monday through Friday, excluding holidays. So if you are only open on Tuesday and Thursday, the legislature doesn't give you extra business days of when you're open. So you have to make sure you still comply within those business day timeframes, even if your particular community is not open on that day. So one of the first things that you want to do after you calculate the deadlines is, and I'm going to run through a few different things that you should do as a preliminary evaluation of your request. And they're not all connected to each other. And so before we move on to step 4, I do have a slide that has these all listed out. So we'll go over that again. But So once you have the request, you know when it's due, sit down and look at the request. FOIA requires that the person describe a public record that sufficiently to enable a public body to find the public record. What this means is do you understand what they're looking for? Some requests are not very clear. Some requests are way too broad. So I'll give you an example from a real life FOIA request that happened to a community. Someone submitted a FOIA request asking for everything involving the budget. Okay, no time frame, no other clues, just everything involving the budget. You know, what doesn't involve a budget? You know, obviously the budget itself, but is it minutes of the budget meeting? Is it any request to amend the budget over the whole course of the history of this particular community? So do you understand the time frame and scope? If you are going to deny or deny in part because of vagueness or overbroad, it's vague and overbroad, that's typically the terms that we would use, I would seek legal counsel, because sometimes you want to raise the issue, but also, grant it or deny it to the extent that you can identify documents. And this is what I mean. Like if, for example, a common FOIA request is someone's upset with the township. Someone is upset with the township. They don't like what's going on with a particular property in the township. So what they will do is they will say, I want all records related to this property. Now, if over the last few months of board meetings, there's been a rezoning request or other things, if you look at it, just as it's written, there's no time frames, is it the whole history of the property? So sometimes what we do is we say, look, it's not sufficiently clear, there's no time frame, it doesn't, further describe what aspect of the property you are looking for, but we sometimes say, but to the extent that we can identify records, they're granted. Because sometimes what the courts will say is, look, we understand it was broad, but there were some documents that are pretty obviously what they were looking for. So this is one of those things where you may want to get your lawyer involved to see how you respond to this, because this may be some of the things that one of those things that you might want to make clear with your lawyer to see how to approach a particular FOIA request, and it may depend on the circumstances and how it's written. So the next thing that you would want to do is to say, okay, now that you understand the scope, do you have any public records that respond to this request? And I've put here in the right-hand column the definition of a public record. A public record means a writing owned, prepared, used in the possession of, or retained by a public body in the performance of an official function from the time it's created. It does not include computer software. And on the next slide, I'll get you into a little bit of discussion about what a public record is and what it's not. But if you don't have any records or public records that respond to the request, you can move on to the step 6, which in the slides, which is, issuing a denial for those reasons, and we'll get to that. But again, evaluating whether you actually have any public records that respond to this request is important. And I'll give you an example, again, based on sort of a real life request. There was a FOIA request that went out a number of years ago where they asked, this township supervisor or city manager, we want every email that was sent and received, on this particular day. So let's just say you have that request and you have an inbox of a supervisor's emails. Is every email in the box? And let's just even say, for the sake of argument, that it is supervisor at township.org. So it's the supervisor's official supervisor's email. Is every record in that email, in that inbox, a public record as defined by FOIA? Maybe, and maybe not. So obviously, if the supervisor sends an email to the township manager asking for an agenda item to be placed on the agenda, certainly that would be something that's governmental business that we would all understand would be a public record. But let's say that the next email is a supervisor sending an email to his sister asking for, when they're going to take their mom out to lunch for Mother's Day. It's, a public email system. He's a public figure. It was when he was in his office hours. Is that a public record? No, because it was not in the performance of an official function. So you have to look at the content of the record, not the location, and to make sure that it meets the definition of a public record. The big thing right now is FOIAs for emails and texts. And I think one of the biggest misconceptions is that if you have a personal cell phone that's not paid for by your public body, that the texts and those information on that cell phone are personal to you. And that is not the case. Again, the definition of a public record is how and is the subject matter and the nature of the record itself. So again, if you're on your private, you pay for a cell phone. If you are the supervisor again, and you send that same email, send a text to your township manager asking that agenda item be on the agenda, that text itself is going to be a public record, which raises two issues. One, record retention. You want to make sure that any document that needs to be retained is being retained. It's very difficult with text, so be careful of that. Secondly, email and text tend to be informal. And I have seen a lot of people say things in texts that they wouldn't say otherwise. And you have to be very careful of that because people are asking for texts now routinely. So my rule of thumb is if you're a public official, and you're dealing with the public, you're dealing with other people in your board, and on your council, don't send a text or put anything in email that you would not type up a letter, put a stamp on it, and put it in the mail. Seen this too many times, so it's just be very careful. Email is also dangerous, and if you're going to attend our Open Meetings Act webinar that we're doing in a few weeks, you'll see this is a problem with an Open Meetings Act. But if you send an email and you send it to your entire board or commission, and people start emailing back, that could be an Open Meetings Act issue. And then now you have a written record of the Open Meetings Act violation because now you have everything in writing with respect to that. So just be very careful. Look at the nature of the content. Make sure that you're being very careful about how you're using email and text. And those things should be take into account when you're getting a FOIA request. So do you have the public records? You have to keep your record retention policies in mind. If someone asks you for records that are 15 years old and you don't know, and you know that you don't have those because you've been following your record retention policy, it's really important to understand that before you go through a lot of extra work trying to search for records if you know that you don't have those records. So again, do you have a public record that responds to the request? There's a number of emails, and maybe many of you have gotten emails lately in the last 2 weeks where there's companies that are, I guess, data mining. They're looking for information that they can then resell to other people about your contracts, about your employees. So recently, for example, there's a big mass email that went out asking for asking for a bunch of information about your contract. So name of a vendor, vendor number, line item invoice, a number of different categories of documents about vendors. Okay. And what they want you to do is go into your software and download a report. Okay. And I'm going to give a little bit of a caveat here because the Freedom of Information Act is a 1976 statute. And for those of you who were alive in 1976, there's no software, there's no Excel spreadsheets. If you had to create a record, that meant you had to handwrite it. You had to, take a typewriter and retype it. And so the FOIA does not require you to create a new record to respond to a request, and it doesn't require you to make a compilation summary or report. In the new computer age, I think what that means, and my advice generally is that if you can create a record with a few clicks of a mouse, then I think that that's following the philosophy of FOIA, that you should give that out. What you're not required to do is to create a new record. And one of the ways that this comes up a lot is you'll have a citizen that will say, I want an explanation as to why the library board decided to take this action. Now, you can send them, minutes of a meeting, and you can send them documents that exist, but there's nothing that requires you to type up a response to this person and say, this was all the discussion, this was the theory, this was the reasoning. If you don't have an existing public record, you are not required to create one. So again, and then sometimes I have clients that will create the record to respond to it and then wish they hadn't created the record. So be really careful about creating a record in situations where you don't need to. With respect to the vendor example, and I do want to just take a minute to talk about granting and denying in part. We'll get into this a little bit. But if you have some of that information, but not all, you can grant in part and deny in part. But you don't have to create this record with all of the information that they're asking for. And we can talk about that a little bit more when we get to that part. The other thing you need to ask, are they asking for existing documents or are they asking for future correspondence? And an example will be, I want all the correspondence between the city and the EPA, and then all future correspondence, between the city and the EPA. So the first part of that, they're asking for existing records. That's a typical FOIA request. Any documents that they're asking for future, they want you to keep sending them documents. That's called a request for a subscription. And a request for a subscription is a part of the Freedom of Information Act, but it has certain requirements. First of all, it can only be, you only have to honor that for documents that are created, issued, or disseminated on a regular basis. And it can be only valid for up to 6 months. So using this EPA example, we would deny the request for the subscription because the EPA and the city don't correspond on a regular basis about a particular issue. It would be more of an ad hoc or intermittent type of a conversation. Other subscriptions that may fall within that, certainly agendas, those are created on a regular basis. Minutes are created on a regular basis. One of them that we frequently get are monthly legal bills. If your law firm issues you bills on a monthly basis, that may fall into a subscription. So if that's the case, you can, grant it or grant it in part, depending on if there's exemptions, but then let them know that it's only valid for 6 months and we give them the deadline. So again, if they've asked for a subscription, ask yourself whether they are created, issued, or disseminated on a regular basis. And again, we can address once we get into the substantive denial, whether, how you handle that from a granting and a denial perspective. Another part of step 3, so when you're in your initial intake position, is do you have access to all the documents? Some communities have IT departments or IT groups that can search for an email. So let's just say the FOIA was, I would like a copy of any email sent to any official township email address regarding a certain subject. Okay. If that's something you can search then and have access to, that's important to know. The problem is when you have requests for records that you may not have control over. One of those is, again, we'll go back to the text. If someone's asked for any text messages between council members or board members, you might not have access to that. You probably don't. So one of the due diligence things that we recommend you do at this stage is to send. We have a form that we send to, or we recommend that you send to each individual, stating what the request is and asking them to turn over documents. And then if they don't have documents that respond, certify that. So that's something you can put in your FOIA file, so that as FOIA coordinator that you've done your due diligence and you've done your search. Because we often have times where someone, let's say you have a 5-person board, you'll send out the email, the FOIA request, and say, hey, they're looking for text messages between, board members. Can you send me the text messages? And you'll hear back from board member A, B, and C, and you'll never hear back from board member D and E and just assume that they don't have records. Well, if there's an appeal and you find out later they had records and you just never heard back, one of the things that, will be an issue is whether the township or the library exercise their due diligence in actually searching for these records. So you want to make sure as FOIA coordinator, you've exercised your due diligence. I want to step back and talk about FOIA requests that maybe are documents that may be held by third parties. Whether a document held by a third party is a public record of your community is really going to be something that is a legal analysis of the situation. And so, for example, if they've asked for all copies of the site plan, and the city doesn't actually have copies, but their planner, who's a private planning company, has those, that might be something you're going to be required to get from them. There are other instances where the courts have said, no, the documents held by third parties. For example, there was a case involving a legal investigation that the lawyer did an investigation, did a report, but never shared the report, just verbally reported on the findings, and the courts found that the actual report was never a public record of the community. So before you actually go out and get a document that you might not have, this is one of the areas where I'd really have you seek legal counsel to determine, is it a public record of your community, and what obligation do you have to retrieve it? You may have an obligation to get it from the third party, you may not, depending on the circumstances. So this is a really good time for, it's a really good use of your legal services to do that. So another part of step 3 is just to recognize whether they're asking for an inspection and a copies, because when you're doing your analysis of the fees, you have to make sure that you're not charging them for copies if they've asked for an inspection. So that is part of the intake process of a FOIA request, is to know whether they're asking for copies or for inspection. So I want to review step 3 because I think this is probably one of the most important parts, because this is where you're going to decide. And this should be done in the first 5 business days, so you can really decide what steps to take from here. But understanding the scope of the request, do you have public records that respond? Are they asking for a subscription? Do you have access to all the requested documents? And are they asking for an inspection copies? So this is something to really tackle, because whether you understand what they're requesting, it might be that you reach out to the FOIA requester and ask them to clarify something. This is a lot easier to do in the first 5 business days than on day, the 14th business days when it's due, if you've asked for an extension. And so that's why these are the steps that we think are very important to take initially before you get into to other parts of the FOIA request. So after you've done your initial intake, this is where you pause. And again, we recommend that this is done in the first 5 business days. So do you need more time? And this is the time where you ask for a 10 business day extension. This is a unilateral request. You don't have to have permission from the requester to do this. You do have to provide an explanation. Typically, it's simple as, you've asked for a lot of stuff. It's a broad request. We need additional time to process and review the FOIA request. So you calculate the date. You have to include the date by which they have to respond, and you have to give the reason, but you don't have to seek agreement. But do put in the date by which they have to respond. So if it's 10 business days and that is July 8th. Or July 18th, you say, 10 business days, and that's July 18th, so that they know specifically what date it is. Step 5, I think, for me, is one of the really crucial parts of a FOIA process, and that is determining whether you should ask for a deposit. You've always been able to ask for a deposit, but the amendments of 2015 put a lot of things in there that are very beneficial to public bodies. And one of them is that if they don't pay the deposit within a certain time period, and we'll get to that, it's considered abandoned. And there's other aspects to the deposit, so I'll go over those. But you cannot ask for a deposit if the fee is not expected to exceed $50. So that's really the threshold, and that's what you do in your initial evaluation of the FOIA request, is to determine like what records are out there, what do we think we need, because you want to know whether the estimate is going to be $50 or above. If it's over $50, you can ask for one half of it up front. And it has to include a detailed itemization of the estimate. And so again, I told you, we talked about beginning how you had to have a procedures and guidelines, a summary, and the detailization. It's a form that you have to fill out with all the individual parts of the fee. The fee is a little complicated. We'll go into detail later, but it has to have a detailed itemization. It has to have the date of the abandonment in there. And it has to have the date of the best efforts estimate regarding when you think you can comply with the request. So the anatomy of our deposit letter has a few things. It'll say, one, we estimate that let's just use $100. We estimate that the fee will be $100. And then we say to them that we will not process your request until we've received half of the estimate, which is $50. And the next slide will tell you where the 48 days come from, but the statute says if they don't pay that within 45 days, then it's considered abandoned. But the ability to charge the fee really depends on the $50 threshold. So you want to make sure that you understand how long it's going to take, and that you give them an estimate of when they pay the deposit, how long do you think after that? The 48 days is calculated. It's 48 days from the date you send the deposit letter. And the statute builds in 3 extra days for transit. I think they assume that people are doing stuff by mail still when they did this amendment. Most of it is now by email, but it's still it's 48 days from the date that you actually send the email or put it in the mail. So make sure that you know when you're going to send it and you calculate the day accordingly. We also recommend that you throw in a statement, and because we've had estimates that are way off, because once you get into it, you realize, oh, this is a lot more work. So you want to make sure you throw in a statement in the deposit letter that says, that you're responsible for the final fees, even if they exceed the estimate. I want to just stop. There's something that's not in my slide because it's sort of an issue that we can get to, but someone asked me what happens when one person submits multiple separate requests to avoid fees. So this is something you should talk about with your lawyer. My position is that I consider any request received on one day. So if they send you 3 emails on one day, that is one FOIA request. And in our response or in our deposit, we say we received your FOIA request, and then in parentheses, sent in 3 separate emails on this day. And people are doing this to avoid the fees. We are getting some pushback recently from people. I still think that is a valid position, but that's something you should talk to your own attorney about and make sure that they agree with that position. Some communities don't take that position. They have FOIA software, for example, that any separate one comes in, it's given a different name, a different number, and so they process it each individually. That's going to be something that's going to be up to your community to decide. But this really, when I first started doing this, someone asked for 50 years worth of property records, property cards, tax records. I can't remember what it was. And we said, okay, it'll be $100. And then they said 50 separate, it was faxes at the time, asking for each individual year to avoid the fees. And I don't think personally that FOIA was set up to game the system like that, but that's something that should be a conversation between you and your lawyer to determine if that's the right for your community. And again, this is the 45-day requirement, but it's really, which is 48 days after the deposit letter is sent. So include that deadline. So there are a number of advantages to the deposit. So first of all, it puts the requester on notice of the cost. So if you have an outrageously broad FOIA request that you can respond to, but it's going to take 30 hours of work, what you don't want to do is put 30 hours of work into it, get all the documents, you can send them a bill for the 30 hours and have them say, oh my gosh, I never realized it was that much. So the benefit of the deposit, it really puts them on notice. If they don't pay, it's considered abandoned. And we've worked with many communities over the year that respond to a request, grant it, they have a stack of papers waiting to be picked up, 3 reams or something, and nobody ever picks it up because they don't want to pay the bill. There's no real mechanism to recover the costs. If they don't pay, you really have to go to small claims court on a contract action. The communities don't really do that. It's not worth their time. So it's about spending resources of the community before you have a real indication that they understand what they've asked for and are willing to pay for that. And you don't have to process it and do any of the work until they've paid. So again, it's about preserving community resources, your time. Your time is community resources that if you're being paid by the public body to be there at work, you want to be spending it on things other than FOIA requests if they're not going to pay. Another thing that I do want to address here, I think this is a good spot to do it, is harassing FOIA requests. And there's a lot of communities that have serial FOIA requesters, ask for things daily. There's no real mechanism in FOIA to handle that. There's nothing that there's not an automatic shut off if you've sent too many FOIA requests, or if you send 6 FOIA requests in one day, or if you seem to be picking on one, person, you're asking for employment records and all this information about a specific person at the community. There's really no remedy in FOIA in the statute itself to address this behavior. So how do you do it? You do it by responding to FOIA requests very carefully. Don't miss deadlines. Make sure you get everything out on time. Make sure you apply all the deadlines. The other thing is asking for payment and the deposits up front. Because it's one thing to send 6 FOIA requests over the course of 6 days, asking for years and years worth of records. It's another thing to be willing to pay for all of that. So oftentimes you can kind of shut down some of this behavior if the person realizes that they have to pay for it. And it's required by, it's perfectly permitted by FOIA, these fees. I mean, everything's permitted. It's not, you're not trying to do something. That's why you should send requests that everybody pay the fee, and don't let someone have a free FOIA and other people not, because I think you're going to end up in a situation where people are going to say, well, why didn't you make her pay? Why are you making him pay? Again, this is one of those areas where you can save yourself a lot of work. Now, if they pay the deposit and proceed with it, then that's fine. But oftentimes these harassing or type of emails are shut down because they want the information or they want the reaction, but they don't want to pay. So this is one of those areas where I think that communities can really help themselves. So this is going to go over a little bit past 1 o'clock. So it'll be recorded and we'll have the slides for people, but I think it's important to kind of get through all the stuff. So if those of you that have time to hang on, great. And for those of you that can only stay till 1, I do apologize for it taking a little longer, but I want to make sure we get through all of this. If you have, I have a process that I use when I have a FOIA request. If you have a multiple paragraph, let's just say there's 3 numbered paragraphs in your FOIA request, I recommend that you respond to each of them separately, even if the response is the same. Because sometimes when people lump them all together, especially if you're claiming exemptions, it's not going to be clear as to which ones you're granting and which ones you're claiming exemptions for. And then often you'll get appeals from that just because people are confused. So I recommend that that's the process you take, really address each one individually, even if the response is like 7 pages long, which some of ours are, but I think it's important. I think it really helps cut down on the appeals. Also, if they ask for a series of documents, to the extent that you can, respond to those separately. And I've given you an example here. If the example is a request for emails, text messages, memos, and resolutions about ordinance amendment 2025-7, you have an email and resolutions, but no text message or memos. Grant it in part for the emails and resolution, and deny it in part for the text message and memos. Because one of the things is a denials if you don't have a document. We're going to get into that in a minute. But I want to kind of point out how we recommend that you frame the response and really drilling down on each individual thing. Otherwise, again, I think I see more appeals where this is not done. Every response letter, whether it's granted in part, must contain a website link or a copy of your procedures and guidelines and your written summary. That's why it's very important to have it on your website, again, because it's not it's required, but also prevents you from having to attach all these documents to an email or printing out, 20 pages of documents and including it in a written response. If there's a fee, the response must include the fee and a copy of the detailed itemization outlining the fee. And it also should include an estimate. One of the things that it's important to understand is that within the first 10 or 5 business days, you either have to issue the deposit, grant in part, deny in part, grant in part, or grant or deny in full. If you are granting or granting in part, you don't actually have to provide the documents on that 5th business day or the 10th business day. So you can say, and we recommend that you receive, if you've charged them, that you receive the money before you give the document. So a typical response is the fee for your request is $100. See attached detailed itemization. The township anticipates that it will respond to your request within 10 business days of receiving the fee. That's the typical recommended approach that we have in a response to make sure that you get paid first and that they understand how much time it will take after you get paid. Again, you don't want to go through the process of making copies and completing redactions if they never pay. So that's why this is important. It's permitted under FOIA and it should be part of your policy and it should be part of your process for responding. Granting what the FOIA now says is that if you know or have reason to know that a portion of the requested records is available on the website, you can grant it in part and provide the specific web page. You're actually required to do that instead of providing them the copies for that. So again, the FOIA coordinator should have a pretty good knowledge of what's on the website. It'll make it easier for you if you don't have to make copies. You can point them to the web page, but you actually have to put the links of those documents into the FOIA response. If it's granted in full, you can move on to step 7, which is evaluating the fee. But if it's only being granted in part and denied in part, then you must continue with the evaluation, which is what we're doing under step 6. So the remaining part of this is when you have a denial or a denial in part. And there's specific reasons for the denial, and you want to make sure that they're very clear. If you don't have a document and it doesn't exist, you have to tell them that it doesn't exist. And I think some of the mistakes that people make are this. So for example, let's say that you have a document that you think is exempt. And you say, let's just use one that's an appraisal, or a bid, because the bid deadline hasn't been passed, okay? And you have a copy of the bid, but the deadline hasn't passed, okay? You would, if that's the case, then you would cite the exemption. Let's say you never got a bid from somebody, or the document just doesn't exist. You don't use an exemption and say, oh, it's attorney-client privileged or it's exempt, when you don't actually have the document. It's better to say, we don't have the document. And so if you don't have a document, it can be, you deny the request because the document does not exist, or that the community does not maintain the document. There's a slight caveat or a slight variation of this. You can deny it because there's no public records as defined by FOIA. And getting back to the discussion I had about the supervisor's emails, where I said that one of them was to the township manager about a business, then the next was to his mom about Mother's Day. And let's say that the only record that you have is the only email that you have, and they ask for emails within a 15-minute time period, and you have emails, but they're ads from, Cabela's or their, personal correspondence. You might actually have physical records, but they're not public records as defined by FOIA. And sometimes we say that because, the person might say, well, it's a little odd that nobody got an email all day or something. Nobody got an email within this time period. But we can say, well, we just don't have any public records that respond to that request. So if you don't have a document or you don't have a public record as defined by FOIA, you have to provide a certificate that the record doesn't exist. And what we do is we have our response letter says something like, This letter serves as a certificate that it doesn't exist under the name provided by you or another name reasonably known to the township library or whoever you're working with. Again, you're not required to create documents. And so sometimes we say we don't have a document and then we'll add and we're not required to create one. And that's a certain situations, like, for example, if someone's asked a question that they expect you to just draft an answer to, we might say, not only do you not have a document, but inform them that you're not required to create one. So that's sometimes an add-on to the denial. I'm not going to spend a ton of time on exemptions because this is something that the FOIA coordinator is going to really need to work through as far as understanding what exemptions might apply to their particular documents. And with a group like this, it's very hard because there might be people who work with police organizations, and you'll have typical exemptions related to police records. But I wanted to go through some of them that you might be more likely to encounter depending on what type of organization. Information that's a personal nature, things like the police reports have a lot of this in there, sometimes private details about what's going on in someone's home that might be contained in the report. Those would be maybe personal information. It's personal if it's personal in nature and whether the disclosure, this is the analysis, would constitute a clearly unwarranted invasion of privacy. There's a lot of case law on privacy exemptions. I could give a whole hour-and-a-half seminar on privacy exemptions. So if you think something's private and you're not familiar with it, or if it's something you haven't discussed with your lawyer, I think that's an appropriate time to contact your lawyer to ask what the process is and whether they think a particular something is exempt. There's also a frank communication exemption. I put it in here. It's between public bodies that's advisory in nature and other than purely factual. Again, I think this one is used sometimes where you have to be really careful because it's just opinion. So if someone says, I think this, and it's about, it's preliminary to a final agency determination. There's a lot of aspects of this one other than just, someone's opinion in there. It has to be preliminary to a final agency determination. It has to be other than factual. And it also then has to they have a balancing test about public interest. So again, this is one of them. If you've got an email that has some sensitive information in it, and you think it might meet this as standard, this is something you should discuss with your lawyer because there are so many there's a balancing test and other factors that come into play. This is between public bodies or internally. Where this comes up a lot that does not apply is if you have frank communication with an outside vendor, like your planner or somebody else, this will not apply. So again, think ahead and be very careful about what you put in writing. If you think you have a frank communication exemption, be sure before you put it in writing that that's something that actually applies. If it's exempt from statute, FERPA, Library Privacy Act, there's Metro Act, statutory exemptions, lien information, HIPAA. These are the big ones we encounter a lot, depending on what type of organization you are. Again, bids or appraisals, but only for a certain time. Social security numbers, attorney-client privilege information, records that are exempt from because they're a party to a civil action. Test questions and answers. Sometimes communities use the same test to, like police officers or other people that are applying for a job. You're not required to give those out if you're repeating those same tests, answers, or scores. Medical or counseling or psychological facts. Sometimes people say, oh, it's subject to HIPAA. HIPAA has very specific rules, but in a police report, for example, if someone says that they're on a particular medication and they relay this to the police officer, that might not be technically HIPAA, but it certainly would be medical information that you'd want to redact out of that police report. Cyber security, there's been a number of different amendments recently for security issues. So cyber security, you're not required to give away information that relates to your cyber security. The other one that goes along with that, and I put it all in here, but this is maintaining information related to the safety and security of public buildings. So again, if someone's asked for like all the, building specs for your water plant or things that might have safety issues, this is now the exemption you can use. I use this exemption to redact numbers off of, like, for example, if someone's asked for, account information from which, financial information typically is something very subject to FOIA, but you want to make sure all the account numbers and all that information have been taken out. So if it's either exempt, if it's exempt, you have to provide an explanation. And again, this has been subject to a lot of case law. If it has a balancing test in it, you have to explain why the balancing test would apply. For example, some law enforcement personnel records are exempt, and the courts have said that, release of certain information may cause a chilling effect on people wanting to apply. That might be a reason why you can talk about, or you can explain your decision to exempt it and explain how it meets that balancing test. With communities, I want to stress this again, that aren't really familiar with responding to FOIA requests. I do think it's something that, you can have your attorney work with you on, how to address maybe the balancing test or how to explain an exemption. Because the courts have really said you can't just regurgitate sometimes the exemption, like attorney-client privilege. You can't just say it's attorney-client privilege. You have to explain that it was sent or received for the purpose of obtaining legal advice and a little bit more detail to that. So you want to make sure that you have that information in your denial letter. Any denial or denial in part, whether it's denied because it's exempt or it's denied because you don't have the record, must include their right to appeal or their right to seek judicial review and the right to recover attorney's fees and damages if they prevail in court. Okay, so that really is the part on the actual substantive response. I've seen a lot of chat in the email, and I might have to wait to the end if people want to hang on at the end. I can go through some of these and answer these questions, but I want to make sure we get through the slides. The fee is a little complicated, so I have it in the slides. You can maintain copy of the slides. So a public body may charge a fee for the public record if you've established the guidelines. This is again where it comes in. You have to have the guidelines in the written policy in order to charge a fee. So you want to make sure that that's in place. So the fees are limited to actual mailing costs and the actual incremental cost of duplication, including labor for the search, examination, review, and deletion, and exemption of non-exempt information and the duplication of that. So this is what the statute says, and they're broken down into really 6 main components that we'll get to, but we want to go through those individually. You can charge for searching for, locating, and examining. So remember when we were in step 3 in our initial intake. So any of the time that you spend searching for the documents, trying to get them, looking them over to make sure they're in the scope, those are the types of activities that you can charge for. And so keep track of your actual time. You have to keep track of the time and keep track of how many hours. And if you have more than one person, we'll get to that in a minute, keep track of each individual hours so that you can determine if there's a different level of charging them. What's really important about this, we'll call this SLE, that search, location, examination. You can only charge this if you're granting a written request or granting in part. So if you spend 5 hours looking for documents and you don't find any documents, you can't charge them the 5 hours. You can only charge them, you can't charge them anything because it's only for granted requests. So keep that in mind. You can charge for separating and deleting information. This is redacting. This is going through documents and removing information. And keep in mind that these charges can be done and charged even if someone's asked for an inspection. I want to be really careful. If someone's asked to inspect records, it doesn't mean that they get to see things that they couldn't see if they were asking for copies. So for example, if you have a file on a particular, let's say you have a file on a zoning request, and in that file is an attorney-client privilege communication. Obviously, you wouldn't give that to them when they're seeking copies. So make sure that's removed from the file for the purposes of the review, or things are deleted. You can delete things and redact documents and include the redacted documents back in for inspection, but make sure that you understand that someone that's asking for an inspection does not get to see things that they would get if they were just asking for copies. The third type of labor cost is the costs associated with duplication and publication. So if you have to scan in, 50 pages of documents and email those. That's what we're talking about here. So you have to keep track of these separately. So before 2015, when this was enacted, if you had a FOIA request, you got the documents, you redacted the documents, you copied them and you put them in the mail and you sent them. And that all took 2 hours. Okay. That you charge them 2 hours of time. Now you have to say, okay, well, it took me 45 minutes to search, locate and examine. It took me a half an hour to redact, and it took me 15 minutes to duplicate them and put them in the mail. Those actually have to be accounted for separately. So be very careful that you do that. So the labor cost, so we have the 3 types of labor that we discussed. The labor cost, you can't charge more than the hourly wage of the lowest paid employee capable of searching for, locating, and examining the public records, okay? This is true of all things. There's one little aspect of redaction that we're going to talk about, but it has to be an employee. So if you hire a company to do like your IT work and that company does a computer search, you can't charge for their time. So it's only an employee time. Yes, you can, if the highest paid person in your organization is the one that's the only person that has access to these records, you can charge their time. I will tell you that this is one of the areas where I've seen a lot of pushback lately because hourly wages have gotten very high. And so, sometimes it's $70, $80 an hour for some of your senior officials. So you can always, the safe spot is always to charge the lowest paid person in your organization. They can't argue about that, because that fee can only be charged whether it's whether that person is available and who actually performs the labor. So, for example, if the lowest paid person is your deputy clerk, and the deputy clerk is on leave for 3 weeks, and the deputy clerk could do that function, but the clerk now has to do it who may be paid higher, you only can charge the deputy clerk's wage. So one of the safe havens is really to charge the lowest paid person in your organization again, and they can't argue with that. Labor costs shall be estimated and charged in increments of 15 minutes or more with partial time rounded down. This is for search, location, exemption, and separation and deletion, or search, location, examining, and separation and deletion. So what this means is for those first 2 categories, you can only charge if it exceeds 15 minutes. So if it took you 10 minutes to search, examine, and review the documents and 10 minutes to redact, you can't charge for the time because each component didn't take more than 15 minutes. For the duplication and publication, the statute has not given you the 15-minute increment or the 15-minute minimum. So in our policies, you can charge by the minute. You should check your policies because I've seen some policies that still have that 15-minute limit, and you should follow your policy. You may consider amending the policy, but you should still follow your policy until you change that. But for duplication and publication, they don't have that statutory 15-minute. So your labor costs should be charged. So you have to tell them how many hours and what the hourly wage is for each person for all 3 categories. And wages can't include overtime unless they specifically agree. And all this has to be on a detailed itemization. One of the things that the statute kept, I call it the old language because I was hoping when they amended in 2015 it would be out of there, but it states that you can't charge for search, location, examination, or separation and deletion, which is redacting, unless failure to charge a fee would result in an unreasonably high cost to the public body because of the nature of the request in the particular instance, and the public body identifies the nature of the unreasonably high cost. This is something that on your detailed itemization sheet, you should explain why you have to charge unreasonably high costs. And there is some AG opinions on this that you should consult with your attorney about. But some of the reasons we say is that, it's going to cost 25 hours, and that's way beyond a normal FOIA request. And it's going to take the clerk away from his normal duties for that many time. And that's an unreasonably high cost to the township or the library or the city, whoever is doing that. So but you should have some explanation as to why the unreasonably high cost. You can charge up to 50% of that hourly rate to cover fringe benefits, but you have to include that multiplier. So if your fringe benefits amount to 50% of your hourly rate, you can charge all of that, but you have to explain on the detailed itemization sheet what percentage of that hourly rate. Um, for There's something that was added in 2015 that I think is really good. For separation and deletion only, so basically redaction, you can charge, if you don't employ a person capable of separating and deleting it, and the FOIA coordinator determines on a case basis, you can charge for contracted labor costs. So this is only for separation and deletion. You have to put who the person is that's doing it. You have to explain the costs, and you can only charge 6 times the state hourly minimum rate or minimum wage. So I'll give you an example. This comes up most often in attorneys. So if someone's sent a FOIA for legal bills, often it's the attorney that goes through and does the redactions. You can charge 6 times the current state minimum hourly wage for that attorney time for that. Again, it's just the redaction part of it. So you can't pay your attorney, they can't pass on attorney's fees if you ask the attorney to like sort through documents or read out documents that's not redacting, okay? If you're just trying to figure out what's within the scope. Again, it's just for redaction. So typically you can't, if you have to call up your planner to help them assist you with getting records together, unless they're redacting, which would be, I haven't seen a situation in that, you can't really charge for that time. So you can charge for paper copies. They're limited to 10 cents for an 8.5 by 11, and you have to provide the number of sheets. So you can actually charge for physical copies. If it's a huge like site plan map, we typically charge the actual cost for duplication of that, but that should be included in the detailed itemization. You can charge the actual costs of they call it non-paper physical media. Usually it's a flash drive. So it's important to understand that the person gets to stipulate the format in which they want it. So if they want to email to them and you can do it, great. If you don't have email, if you don't have a scanner, you're not required to buy one to comply with the FOIA request. But if you have one, you are required to produce it in that format. Again, I don't recommend that you take flash drives from them. I recommend you buy your own flash drives. You want to maintain the integrity of your system. But if they want something on a flash drive, you can charge them the cost of the flash drive. Also, actual cost of mailing. I don't like sending things certified mail because sometimes people play games and don't want to accept it. So typically, if it's mailed, you just first class mail is typically typically the route to go, or you can charge for the least expensive form of postal delivery confirmation when mailing it, but typically certified mail is not that. You have to reduce the fee in certain circumstances. Again, for certain indigent individuals, and we have had that come up, they have to provide an affidavit, and you only have to reduce that by $20. It's such a small, it happens so infrequently, I don't want to belabor it. And certain nonprofits, you will get, the one thing you will get is you will get newspaper organizations, you'll get individual requesters saying, this is in the public interest, will you waive the fee? You have authority to waive the fee. You can waive a fee if it's in the public interest. I don't recommend that you do. Most of these FOIA requests are really not in the public interest. They're somebody trying to gain information for their own purposes. And then it's very difficult to know, what are the standards? Why would you waive a fee for this person and not for another person? So although you can do it, I typically recommend that communities not do it, or you should have a really good reason of why you'd want to waive a fee. But again, this is a little different. This is required that it be furnished without charge only for the first $20. And I bring this up because these are specific nonprofits that get this. Not every nonprofit or every public interest organization gets this. So that's just one thing to keep in mind, that it's not mandated and it's only for the first $20, but it's very limited to these two circumstances. Again, you have to use the standard form for the detailed itemization. They say you can use the form created by the Management, Technology, and Budget Office, but I typically recommend that you have a form that works for you that does contain all that information. If you don't respond within a timely manner, you have to reduce the charge by 5% for each day you fail to respond, with a maximum of 50% reduction. If either of the following applies. Okay, and this is where, and one of the things I should have mentioned back there is when you get the FOIA request in, if it's not by email, make sure you save the envelope, because this is the only time where using the word FOIA actually becomes important. So you have to do the late response if the late response was willful and intentional. I hope this is nobody on this call that would willfully or intentionally fail to respond to a request. That should never be the case. But, or if the written request contains language that's conveyed within the first 250 words of the letter, fax, email, or email attachment, or specifically includes the words for Freedom of Information Act, information, FOIA, or copy, or recognize misspelling, either on the front of the envelope or on a fax page or within the body, as it says here. So again, they don't have to use the word FOIA to be a valid request, but they might not get this reduction. If you're accidentally late and they don't use any of these magic words here, then they don't get that 5% reduction. And if you do reduce it, you have to note that on the detailed itemization. I don't want to spend a lot of time on this because I've never seen it happen, but you can ask for a deposit up to 50% in most cases. You can ask for a full deposit of 100% if there's 6 statutory requirements. They're so hard to meet it. I don't want to spend a lot of time on that. I haven't seen a community yet that's been able to do the 100%. If you are able to do the 100%, you no longer required to or allowed to do that if any of the following apply. That individuals show proof of prior payment, the public body is subsequently paid in full, or 365 days have passed. So again, if someone's been able to successfully do the 100%, I'd love to hear about that, because I just haven't seen a case where it's been where it's happened yet. So now you've sent and again, the policy should be that they have to pay the fee that you calculated in order for them to actually obtain documents if you're granting it. Within 10 business days after receiving an appeal. So let's say you've got the denial's gone out, the FOIA request has been responded to, and now you received an appeal. Within 10 business days after receiving the appeal, the head of the public body must either reverse the denial, issue a written notice upholding the denial, or basically denying it in part. An appeal must specifically state the word appeal and identify the reasons for the disclosure. So there's been cases where we've said the appeal is not valid because they just said, we appeal the denial, and they don't give any reason. Doesn't meet the statutory requirements of the denial, and the public body won't hear it. Typically, they do include some reason, but it does have to state the word appeal. So if they just said, I don't like what you said, I don't like how you responded, and here's why, but they never use the word appeal, it's technically not an appeal. You can, under unusual circumstances, you can issue one notice for no more than 10 business days. A public body, if your township board, if your library board is considered the head of the public body, you are not considered to have received the appeal until the first regularly scheduled meeting following the submission of the appeal. Here's the problem. Timing is everything. So let's just say you're a library board that has a meeting on Tuesday, and you don't meet again for another month, and you receive a FOIA appeal on the Friday before the Tuesday. You have 2 options. One, it's not considered received until that Tuesday. You have 10 business days to respond, which would mean a special meeting, or you could respond on that day at the board level. And so that sometimes the timing issue will depend on how you process that. But if you don't respond to the appeal, they can seek judicial review of that. I will say for appeals of denials of FOIA, these are the substantive appeals, they don't have to appeal first. They can go right to circuit court. And usually they always appealed, but lately we've seen a trend where people are going right to court. Okay. The other thing is the appeal of fees, and this is something that is new as of 2015. But if you have it in your procedures and guidelines, which you should, that they can appeal the fee, they can't take you to circuit court over the fee until they've appealed. And sometimes that's really good, because your public body is going to get a second bite at the apple on the appeal issue before they're faced with any litigation on that. you can decide whether the fees were reasonable, but this appeal letter has to have a certification from the head of the public body that you've determined that the fees are accurate. It should state, this is the exact language from the statute, and it should state that in there. Again, there are penalties for intentional or bad faith. FOIA, you don't want to be in a situation where you have to really worry about the penalties. We want to be in a position of compliance, but just to be aware that there are penalties for willful, intentional, and bad faith. And also, if you've arbitrarily and capriciously denied the FOIA request, they can take you to court and they can ask for damages and civil fines. Some of these civil fines don't go to them, they go to the state, interestingly enough. But again, that would be something that the municipality would have to pay. And